And I then worked at what is now the National Director of Public Prosecutions, but was then the Attorney General for a year. And I then resigned and went to the bar.
And for how many years have you been at the bar?
28.
For how many as a junior and for how many as a senior?
6 as a silk and 22 as a junior.
Yes.
The 22 years were not consecutive. It was interrupted at the end of the 80s by a 5-year period during which I worked for mining houses, primarily looking after labour relations and industrial relations matters.
What percentage of your practice has been in the labour law field?
Since 1993, 95%.
And for how long, all in all, have you acted in the labour court?
3 weeks.
Tell us why you consider yourself to be suitably qualified for the position of labour court judge.
I meet the requirements set in Section 153 of the Labour Relations Act, which is I need to be an admitted legal practitioner and to have knowledge and expertise and experience in labour law. And that I have not only from the point of view of a legal practitioner, but I was actually, if you'll excuse almost the pun, at the coalface when I worked for the mining house.
Yes. Thank you. Let me just, before we move on, just welcome Acting Judge President Taleti, who is the Acting Judge President for the Labour Court and the Labour Appeal Court, and Mr. Njalinjali, who represents NADLAC. You're welcome, sirs. AJP.
Thank you, Chief Justice. Morning, Mr. Beaton.
Mr. Commissioner?
Yes. In the 3 weeks in which you acted in the Labour Court, that was during recess, all
Yes.
those times,
It was a pro bono appointment.
on the pro bono program.
Yes.
Yes. So for 3 weeks, how many days would you have sat in court hearing cases?
2 in each week.
2 in each week, which would give us 6 days.
Yes.
Okay. And the kind of work that we do during that period, is it opposed motion?
Yes.
That was the opposed motion, yes. And then on your questionnaire at paragraph 2, you have referred to an article that you wrote in 1989.
That is correct.
Yes. What is the significance of that article? What's important about it that you'd want to share with us?
At that stage, there was no Section 33A of the Labour Relations Act, which allows the enforcement of collective agreements. And this article addressed that. It has, of course, in the light of statutory developments, become quite irrelevant at the moment, but at the time, that was why I wrote that article.
I see. And then also you have attached a ruling on a disciplinary inquiry.
Yes.
That you had. What is the significance of the ruling?
First of all, the ex-judge who chaired it himself said that the offence of which I was found guilty was not a serious one, and he would have only in the normal course have imposed a warning for it. He described it as an error of judgment. The sting in that disciplinary finding is that he disbelieved me because I denied...
No, I'm not. I'm referring to the one on the matter of
I beg your pardon.
RMD Quick Forum
Yes.
and TFSL.
That was... My apologies.
Yes.
I was briefed to chair a disciplinary hearing against an MD, and one of the charges was a conflict of interest. And it was necessary to expand upon exactly what is a conflict and how much disclosure need there be in order for the charge of a conflict to evaporate. And this ruling addressed that point.
I see. Okay. And then, just for information purposes, the demographics at the labor court at the moment are as follows, because I've seen in one of the packages there seems to be a mistake by the, I think it's by the GCB. We've got 4 women at the moment. We've got 4 white males, and then you've got 2 black males. You've got 1 colored woman and 1 African woman. Out of the women, you've got 2 white women. Do you have any comment regarding your appointment?
I would suggest that demographic representation at the Labour Court, in any event, plays less of a compelling role than it does at the High Court because of the provisions in the Labour Relations Act to which I've just referred, which I would submit are the primary considerations that you should take into account. It seems to me as though this commission itself holds that view, because 3 of those white males to whom you've referred were appointed in one sitting on recommendation of this commission.
I see. And then in your package also you made a disclosure which was a finding by the disciplinary committee of your professional body.
Yes.
Yes. Seems the proceedings were completed last year.
Yes.
Yes. And the sanction that was imposed, is it still in operation?
It was a suspended sanction, and the suspension period is still operational, yes.
So technically, would you say you are still serving a suspended sanction, or how does it operate?
Well, the period of suspension is still operative.
It's still
yes.
operative. I see. That is all, Chief Justice, I thank you.
Thank you, Acting Judge President. Commissioners, for the sake of the new commissioners, when it comes to the Labour Court and the Labour Appeal Court, we have the Judge President of those courts or his designate or deputy in this case representing the court. But we also have a representative of NACLAC, in this case, Mr. Njali, who then represents NACLAC, obviously, but he puts questions. He's allowed to put questions to all the candidates, although he does not have the right to vote. So I just thought I must let you know. Over to you, Mr. Njali.
No question at this stage, Chair.
Thank you. Thank you very much. Commissioner Norman?
Thank you, Chief Justice. Good morning, Mr. Beaton.
Morning, Madam Commissioner.
Yeah, I just want to understand, if your sentence then is still operational as it is, why would you think that this commission should appoint you or consider you as a judge?
The sanction has been imposed. The disciplinary hearings are complete. And of course, if you were to appoint me, it would take me out of the cadre of the professional body which has imposed it. But that's my answer, because the professional proceedings and the disciplinary hearing is complete.
Now, let's just go back to the findings. Am I correct that that disciplinary hearing was headed by a retired judge? Am I correct?
Yes.
And if you go to page 106 of the PAC feedback from law bodies,
Yes.
do you see that?
I'm afraid I wasn't given that. Are you talking about my bar or the GCB?
No. Well, could you have a look at this PAC? There is a PAC in front of you.
I see. Sorry, if you could just tell me where the
Yes.
pagination is.
Yes, the PAC in front of you would say book 1 of 1.
I have it.
April 2017, feedback from law bodies.
Yes.
Yes. And the GCB has commented on you, and that, if you turn to page 106,
I'm sorry, the document I have doesn't seem to be paginated.
is it? Okay, can I please ask the Secretariat
at
to just make?
Top right.
Yes.
I'm afraid I can't find
Okay, we'll find it for you.
it. I have it?
You have it now?
Yes.
Thank you very much. Could you please turn to page 106?
I have it?
You have it there? Could you just look at the very last paragraph before the number 22?
Yes, I've seen it.
Yes. That committee that disciplined you found your behavior to be scandalous because you denied under oath that you had interviewed an acting judge in chambers.
Yes.
Now, are you suggesting that, as far as you are concerned, that's not something that should be held against you if you are appointed as a judge? That qualifies you to serve as a judge?
I was, first of all, no, I don't suggest that it shouldn't be taken into account. What I do suggest is that if you read the complete finding, you will see that the actual conduct was found by the judge not to be serious, but this portion to which you're alluding was found to be serious.
Yes.
Now, I today still aver that I did not interview the judge. I know a lot better than that, but I have the finding that I have to deal with. It's the problem, I would ask you to take into account, it's the problem that someone who is accused, who just denies something, faces. And I faced that problem. I was not prepared falsely to admit that I had done it. I'm aware of the fact that these findings are there and that we have not appealed them. I have not appealed them to the GCB. I was advised by two senior counsel who are colleagues of mine that for the sake of the bar and in order to put it to bed and because of the penalty that was imposed, I should not so appeal. I would ask you then to take into account the totality of the findings and the fact that this is one incident over a period of some 28 years that has taken place.
Now, could you tell me who signed your certificate of good standing?
A member of the Bar Council.
But is that how it's done?
Yes.
With the Pretoria Bar?
Yes.
Does the chairman of the bar know that you have a certificate of good standing that comes out of that bar?
Yes.
Now, I've never heard of a situation where a person who has a sentence having over his head would get a certificate of good standing, because it means that that person is actually saying to this commission that, yes, this man has been convicted, has been found guilty, this man has a sentence hanging over his head, but we still feel that he must be a judge.
That certificate at the end pertinently says there are no pending disciplinary hearings against me. I disclosed this in this application, and my bar, in fact, commented on it. So it was known to the bar when they commented on my application.
But then your bar in that certificate doesn't say that there is a sentence that is still pending, that you are serving.
No.
Thank you. Thank you, Chief Justice.
But doesn't that certificate have the effect of saying, you are so clean, this body should have nothing to worry about as far as you are concerned?
Yes.
Is that a correct reflection of the position?
I
Now, reflect on that now as a potential judge. Judging that situation, is it the correct and appropriate reflection of the position?
I would suggest yes, if you read it with the bar's, my bar's comments on my application, which were submitted to the GCB, which I assume are here.
Commissioner Msomi, or is there a follow-up, JP?
Yeah, it's a follow-up from me.
Yes.
Oh, thanks, Chief Justice. I would like you to put yourself in the shoes of the broader South African populace. You are found guilty in 2016 of what appears to have been a serious offense if the comments that Commissioner Norman read through. The Judicial Service Commission, a body that is entrusted to nominate, to interview and recommend judges' appointment, makes a recommendation that you be appointed. How would the broader South African populace look at this particular body? Appointing a man who's got a sentence basically over him, who hasn't completed that sentence, where serious remarks of this nature were made, gets elevated to be a judge. How do you think an ordinary South African will view this body?
Okay.
And the judiciary.
Yes. My first comment is that it's not the offence of which I was convicted was, the judge himself says, was not a serious one. But I take your point that it's these comments. And my answer to your question is that the broader South Africa will accept that people make mistakes and that there are processes which get followed. And in this one, I've been tried and sentenced, and it's in the past. And there is no probability or no indication of any possibility of something happening in the future. I accept that what I've just said does not cover the fact that the period of suspension is still operative.
Just a follow-up question on that. Don't you think it's too soon a period that you are availing yourself? Don't you think, as a value judgment, perhaps there should be some kind of a cooling off period between the time you are sentenced, you serve your sentence, you show some kind of rehabilitation, and then you raise your hand later and say, I've paid my price, I've cooled off for 2 years or so, I'm now ready. It's a value judgment.
Yes.
Don't you think a reasonable person in your shoes would be expected to do that?
If, my reaction to that is that this offence took place in January 2015. So there has been a period of more than 2 years during which there have been no disciplinary actions against me other than this one. So I attempted to expedite the hearing, but with the bar's procedures, they only got round to actually doing anything in June last year. So given the period that has lapsed since the offence was committed, I would suggest that I have met a period of reflection and rehabilitation.
But as a lawyer, you know that the sentence comes into effect when it is handed down, which was only in July
Yes.
2016.
I accept that.
And a mere 8 months later, you get elevated to the bench when there's still a cloud hanging over your head, as it were.
I would submit that cloud has greatly evaporated given the amount of time since the offence was committed.
So much, Chief Justice. I have no
Thank you, Commissioner Msomi. Judge President Komo.
Advocate Beaton, you are a senior counsel. And in this commission, I have, over the years, in circumstances maybe slightly different, with a cloud hanging over them, suggested to them and even sometimes implored them, withdraw. Now you're only harming your own chances in the future, because more questions are going to follow And for me, having looked at what has come, and I'm speaking only for myself, you must remember, although I represent the judges president, you're harming your chances even further. And for me, to persist in continuing, it shows that, for me, you lack judgment. Wouldn't you consider, at this point in time, to withdraw?
If I could,
I don't want to name names, but there are at least 5 who have pleaded with them. Some accepted it, some didn't, and they have been harmed.
this is not a light issue for me. I seriously considered this aspect. I discussed it with colleagues at my bar, and if you read my bar's comment on it, they accept that it is an unfortunate incident, but no one at our bar suggested that it disqualified me and that I should withdraw the application because of it. And if you read the whole judgment, you'll see that what actually sparked this was a complaint that I laid. But I hear what you say, Judge President. I wasn't approached by anybody before, and given my bar's approach to it, I've come this far. I might as well go further. And there's another factor, if I might mention it. And I hear what both of you say about taking time to reflect. I am, you will see from my application, I'm 60. Given the provisions of the Judges Remuneration Act, I've reached my sell-by date.
It's your call. Thank you, CJ. I have no further question.
Thank you, JP. Commissioner Schmidt?
Thank you, Mr. Beaton. You will appreciate that the integrity of a judge is first and foremost.
Yes.
As I understand, you have made yourself guilty of unbecoming conduct by the Pretoria Society of Advocates. Am I correct? From what I understand here, it says contravention of Rule 410, guilty of conduct unbecoming and disgraceful. Is that correct?
Yes.
That's one thing. Admitting it or denying it is another thing.
Yes.
Because if I understand correctly, you are still denying that the incident took place.
Yes.
Which brings
Can I just-
which brings me to the following problem, because on the face of it, then not only do you put into dispute the integrity of another acting judge, but also of a lady, I don't know who she is.
She was the registrar
registrar, yeah.
of the judge, of the acting judge.
Yes. So it's an ongoing problem, one which has not been resolved by the mere fact that you have decided not to appeal. You are
May I
Yes.
react to that?
Sure.
That judge, that acting judge, and I have made peace.
That may be so, but the point is, there is still a dispute as to whether the incident took place. And
Look, I accept the finding. I don't want to interrupt you.
Please, Mr. Beaton, let the commissioner put a question to you. He will allow you to answer fully.
I don't want to put it in too dramatic terms, but it's your integrity which I am questioning about. That is, either you accept that it took place and you say, sorry, I've done it, it's over, or you say, I'm not accepting it and I'm appealing it and we await the outcome of the appeal. But you can't have your cake and eat it.
I accept that.
And that's why I have a problem with what you're saying, because you seem to say, well, let's accept it took place. I'm willing to say it took place, but in the meantime, I'm not willing to accept that it did in fact take place.
There's a finding against me which I've not appealed, and I accept that finding stands.
But then when I ask you whether it did take place, you say no.
I would be untrue to myself if I admitted that, because as far in my heart of hearts, I know it didn't. There's a finding against me, I've not appealed it, and I accept that.
Mr. Beaton, I'm sorry to say this, but I can't believe that we're having a discussion with the senior counsel of the bar. having that kind of argument. With due respect.
Look, for purposes of this commission, it took place. There's a finding against me, and I accept that. I do.
What do you mean for purposes of this commission? For what purposes has it not taken place?
My own heart and head. In my own heart and head, I would, and I don't want to belabor this, I would never do such a thing. But there's the finding against me, and I accept that. And I accept that you can work on that finding against me.
Commissioner Didiza?
Thank you very much, CJ. Commissioner, sorry, Advocate, good morning.
Morning.
You are saying in your heart and head it didn't happen. If that's the case, didn't you feel it was necessary to appeal the sentence if you did not really agree with it?
Yes, I've answered that. I went to 2 senior colleagues who said that for the sake of the bar and because of the sentence that was imposed, don't appeal it, because it'll just carry on this tension that there is. And I accepted that advice.
But didn't you think that the blot of the sentence and it not being appealed raises issues of integrity on your part?
Yes?
You didn't think that was necessary to deal with, because looking at it and what is difficult, you are saying you have come this far and therefore we must examine you even though we know what the sentence is. And one of the commissioner asked, what do you think of the South African citizens? How will they take this? Because if that's the case, why should people be asked to serve the sentence to the end if, when it comes to judicial services, they can actually, judicial officers, they can continue their life regardless of whatever sentence may be there. And it must be accepted that there is nothing wrong about it.
I was unaware that a suspended sentence would preclude me from being seriously considered. If that is the case, I know that this commission does not consider persons against whom there are outstanding disciplinary actions until those have been completed. If that includes the suspended sentence, which I did not know it did, I would be willing to accept that.
I think the problem relates to what that sentence is about. What does it relate to? Dishonorable and disgraceful conduct? Can you imagine a dishonorable and disgraceful judge? That's serious. This is a profession of honor.
Mr. Chief Justice, I've dealt with that.
Yes.
I've answered that. Whether my answer is good enough, I don't know.
Yes, thank you. Commissioner Masuku?
It's a very serious thank you, Chief Justice. It's a very serious concern, Advocate Beaton, that you have not really accepted and honored up in as far as this finding is concerned. In other words, you don't recognize this as binding on your conscience.
That is correct. I recognize it as binding in my professional standing and for all other purposes. But in my own head, I still, in my conscience, as you said, I don't.
That's a very frightening display of, I must say, a very concerning sense of what it means to be a senior counsel and a member of the bar. That you come from a professional body that has found you guilty of conduct unbecoming and disgraceful. You come to a JSC commission, you're asking to be considered for judgeship. You don't appeal the judgment of the professional body you come from. And then you want this body to consider you to be a fit and proper person to be a judge. It's just an unimpressive way of analyzing your own personal circumstances with respect.
I accept what you say, but I cannot.
Sorry, I don't understand. If you accept what I say, why are you here?
Because for two reasons. In my own mind, this didn't happen, but I accept that's irrelevant for current purposes. I
So
accept
please,
there's a
give us something that is relevant.
Okay. I accept that this happened. It's past. It's 2 years since the offence was committed. I haven't done anything in that period. My own professional body said this wasn't serious enough to discourage me from coming here. That is why I'm here. I've given you my personal circumstances as to why I'm here.
Okay, thanks, Mr. Beaton. Thanks, Chief Justice.
Thank you, Commissioner Masuku. Advocate Beaton, thank you very much. You're excused.
Thank you.